O som do pessoal do Zoom já vem para a gente aqui? Hi, Jennifer. How are you doing? It's a pleasure to receive you.
Hi, Gabriel. How are you?
I'm fine. What about you? You don't know what kind of weather you're missing here. You couldn't imagine. 28 Celsius.
We got 10 centimeters of snow last night, so I'm aware just how much luckier you are than me.
Okay, so yeah, Professor Jennifer Chandler is a professor of law in the University of Ottawa. With plenty of a very prolific author of a lot of publication, very important articles in neuro law and other issues of bioethics and biolaw. As said, Canada sometimes, even being one of the most loveless countries, has harsh weather. I mean, I will say the same thing that I said in the online version of our meeting about how good Jennifer classes are. I just crossed the whole city of Ottawa biking in the snow to take part in the debates and listen to her and her community of a very vivid community of a professor in great interaction and intermeshing with her PhD students, master students. So it's a pleasure to introduce you. Without further ado, Jennifer Chandler.
Hi, Gabriel. Thank you. I'm wondering if people, whoever is in charge of the Zoom, could allow me to share my screen and also perhaps turn on my camera.
Por favor, deixá-la compartilhar a tela no Zoom.
Perhaps my slides are more important than seeing me, but I leave it up to you what you'd like to see. Okay, great. It looks like the slides can be shared. Let me do that. Can I confirm that you see my slides, Gabriel?
Perfectly, full screen.
Okay, great.
We don't see you. Can you turn on the camera?
My capacity to turn on my camera has been stopped by the host. So the host will have to give me permission.
Alessandro, você pode deixá-la abrir a câmera, por favor?
No. Yeah. Okay, good. Now okay. We see you. No. We did for a while. Você consegue levantar o...
It continues to say unable to start video because host has stopped it.
Ela está dizendo que ela não consegue porque aí. Just a second.
Sure, sure.
Ela está dizendo que não consegue compartilhar a câmera. Que o host não deixa ela ligar a câmera. Okay, we're trying, Jennifer. First day,
no problem.
All the technical problems show up in the first day. Yes.
Oh, I think it's working. Yeah, here I am. Hi, everyone.
Hi, Jennifer.
Okay. Well, I cannot see you, but I really do wish I was there with you. I'm very sad not to be there. You may be able to hear from my voice. I'm actually very sick. I had laryngitis this morning. I've had a COVID test and I'm negative, but it has not spared my voice nonetheless. First cold in 2 years of living like a hermit, but I seem to have caught something. So it may well be that you're glad I'm not there with you in person, but I wish I were. So what I'd like to talk to you about today is what I've called the legal landscape for neuroprostheses. And I'll explain why I'm going at this and what linkage it has to the theme of this colloquium, looking at free will, agency, and ethics in just a moment. I guess I'm at the far end of the applied spectrum, starting to look at the kind of crude translation of a lot of the complex concepts and ethical issues into the language and typologies recognized by law. And so let me move along then. And this is, sorry, again, I apologize in advance for my voice. I hope it's not too painful to listen to, and I'll also try to remember to speak a little more slowly for the sake of the intrepid translators. So here's an outline of what I'd like to cover here with you. The first question is to say, is there anything actually new to worry about here, or to even think about? After all, prostheses have been used by human beings for millennia. We have figured out how to incorporate them into our ideas of the body, of the mind, of agency, of responsibility, of free will, I assume. And so I'll talk a bit for a moment about, is there anything new to talk about here when we think about neuroprostheses? I'm anticipating where I'm going, because you can see I will say yes, and that there are some types of concerns that are emerging and being articulated, not solely, but kind of in interesting ways in the context of asking for the declaration of new neuro rights. So I'll speak very briefly about that, and a few observations on the role of law in this respect. Before going to where I'm hoping will be most interesting to you as well, is a typology of what I propose as the fundamental human interests at stake here. And these are in part related to agency and free will. They go a little bit beyond that in terms of human interests at stake, but I want to present a full proposed typology. I'll be very interested in the discussion to hear what I've missed and what I've misorganized, what sort of levels of conceptual hierarchy I've confused, and so forth. And then I'll conclude with some legal puzzles for hybrid minds. Some of the issues that I see emerging from the blurring, what I'm calling and defining as a hybrid mind here, the blurring of the wetware and the software of the mind and brain, as well as the hardware and software of the various kinds of neurotechnologies that are enabling both read in and write out of information to the brain, which I'll suggest is creating this kind of hybrid where our former ideas about how to categorize interests are getting blurred and confused. So, as mentioned, humans have used tools forever and have not encountered significant difficulties in understanding their relationship to the self, questions of ownership of the tool, the object, concerns about freedom or responsibility in relation to actions taken, making use of a tool, as well as the rights, duties, and concepts of harms that emerge from their use. But where I'm getting at here is, as we think about tools that are directly of the brain and mind, I'm aware, of course, that the thesis of the extended mind would have folded all sorts of potential things into the mind, but I have in mind here direct interventions, direct connections with the neural substrate, as opposed to more distal things that feed in information to the brain via the senses, for example. We'll see even that kind of distinction breaks down. But I think when we start to look at the tools of the brain and mind, these so-called neuroprostheses, we get some really tricky questions at the level of free will. And I'm not a philosopher nor an expert in this domain, so I'm launching with some trepidation onto your turf, as it were, but in trying to make a linkage between what I'm doing and the types of issues that you're discussing, I'm wondering whether we start to complicate the question of free will here, because we no longer know the free will of whom or of what are we discussing when we get into the hybrid mind. We also get into issues with respect to the mind becoming more of an emergent property in ways that are different from the way it's an emergent property of the body in it or the organism in interaction with its environment in the past. With these neurotechnologies, we invite into that creation of the emergent mind the ideas of the developers of software, the kind of difficult to predict contributions of devices that are set up with machine learning to optimize a particular output based on various types of input that become difficult to predict. So, is there anything new? Here's a little picture of the Cairo toe, which is millennia old from Egypt. You can see also from Beethoven's ear trumpet that we have a long history of devices to replace both lost bodily parts as well as functions. Sorry, just have a sip of water for my voice here. So with neuroprostheses, what is different then? Well, we have direct interaction with the brain that allows reading in of information via, for example, neurostimulation of various types, or write out, attempting to, actually it should be write in and read out, but anyway, you get my point. Devices that will attempt to decode neural data to try to identify for things like the voluntary intention to move a robotic arm, or in recent years, the attempt to decode, for example, imagined speech, which again operates by decoding the signatures from the motor cortex associated with the voluntary attempt to articulate speech, to move the vocal apparatus. We also have adaptive closed loop systems, which are a little different when we talk about prior prosthetic technologies, things that change their behavior in real time. And we move into also the incorporation of artificial sensory feedback, for example, with the use of haptic feedback, where someone attempting to use a robotic arm would have input directly to the peripheral nervous system to create some form of sensory feedback that will help the person to use the device efficiently. Of course, there's also potential networking of neuroprostheses, which is different from past generations of the human encounter with these prosthetic tools, as well as miniaturization. And we also see not just the replacement of body parts, the restoration of functions, but the addition of novel functions, new senses or ways of interacting with objects, whether they're magnetic implants, which you can see in the bottom right, or this idea of bridging brains or brain-to-brain interfacing, which is emerging in the literature as well in a rudimentary form, but nonetheless a kind of suggestive of the kinds of sort of step changes, I would say, in the course of the recent evolution of the neurotechnologies. So why might all this be of interest? I think, of course, neuroethicists love to think about what all this means and what kinds of problems can occur. But I point to recent calls over the last number of years for the recognition of what are called neuro rights, or novel rights tailored specifically to concerns about the use of this type of neurotechnology. And so you can see I've excerpted from the Neurorights Foundation page a little screen grab of the 5 proposed neurorights that are in common discussion. And germane to our discussion here in this colloquium, you can see that one of the 5 neurorights is declared to be a right to free will. So, I mean, this is a shorthand label for something else. And if one reads further, you can see that this means individuals should have ultimate control over their own decision-making without unknown manipulation from external neurotechnologies. So, you know, I read that and I think this is very interesting. I get at what, or I should understand, I think, what this is getting at, but for me, it raises so many questions about the meaning of the terms employed. So what would an unknown manipulation be? What would an external neurotechnology be? And just a couple of quick words about what an unknown manipulation might be in the context of neurotechnologies. I think we can identify some things that would be a fairly clear and unknown manipulation that we would not like very much. But even in situations where somebody uses a neurotechnology, what does it mean to know about the manipulation? So if we think about roughly 10% of people receiving deep brain stimulation for Parkinson's disease who encounter different kinds of unintended psychiatric side effects. And I talked about this in my last discussion with you back in June or July. And so people, about 10%, develop this hypomanic behavior. There's emotional changes, there's behavioral changes, there's disinhibition, impulse control disorders. And people in those circumstances, some of them, when interviewed, appear to retain some knowledge of the change in behavior. They know what's happened, but they're very happy about it. They don't care, in other words. So is it helpful to know about a change, know about a manipulation, if you no longer care about the manipulation? So this gets at, whether this question of knowledge about a particular change really captures what we care about when we talk about free will. Another example for you, I had a conversation this past week with a neurosurgeon who has attempted deep brain stimulation to treat obesity. And I was told about a patient who turns the DBS off when the person wants to go and eat stuff. And so again, it's a vivid demonstration of the fact that the neurotechnology will change certain things about a person and their experience and about their mind. It may well be known, but it may not change other things. And so what I think understanding what it means to know about a manipulation is important. Again, external neurotechnology seems to imply that we have in mind some deliberate puppet master from the outside, but with many of these neurotechnologies, systems that are sort of set in motion and no longer directly controlled, particularly not in real time, raise questions about what external neurotechnology might mean. Bear in mind that some of these are implanted. So even as a matter of geographical location, these are no longer external. So just a few observations on some of the complexities of trying to get at how to clearly describe what we're worried about here, how this fits with the existing and foreseeable evolution of the neurotechnologies, and what is the best way to capture this and respond to it. And I recognize also that sometimes one calls for neurorights as a more of a hortatory attention or consciousness raising exercise than an effort to make a precise articulated rule. And in fact, constitutional human rights are generally stated in a high level, very abstract and general manner. The right to life, liberty, and security of the person. The right, that's Canadian language. The right to life, liberty, and pursuit of happiness is American constitutional language. And notice by the way, as an aside, the national, cultural, or personality difference to pursue happiness versus security of the person as the third element in those two formulations. But anyway, back to the point that the content of these rights is highly underdetermined, and we leave it, in essence, to judges to backfill over time in a way that overrides legislatures. So the use of rights themselves, which legal tool to use to address these kinds of issues, is a very important question. So let's step back perhaps and ask, what are the functions of a legal system and how might one go about tackling some of these concerns? So at a very simplistic level, a legal system is itself a tool, a social tool, meant to influence behavior by letting people know ahead of time what they can and cannot or should not do and what the consequences are. It's meant to avoid conflicts by clarifying protected interests, rights, and duties, and also to resolve conflicts when they arise, but no system can solely operate in that way. There's not enough resources to resolve conflicts. So you really rely on influencing behavior and avoiding conflict. And of course, all such systems must balance competing interests, because there will always be conflicts of interest in trying to decide what the approach is in any given social or human interaction. So where I come to now is sort of the bulk of what I'd like to discuss about is what are the fundamental human interests at stake when we're talking about these neurotechnologies. And I propose to you 5 categories. And I'll start with perhaps the most obvious one. It may be so obvious we might not even think about it too much, but quite obviously we have physical interests in prostheses, including neuroprostheses. So if we look at the schematic on the right, you can have prostheses that are wearable, inserted or implanted. Stent rods, for example, are implanted, deep brain stimulation. You can even have them at a level of what I'd say much greater or less reversible implantation, so what we might call integration. So optogenetics is an example. If we modify cells genetically as part of a neuroprosthetic endeavor, that becomes extremely difficult to remove and undo. So the integration of the technology physically entails a certain number of consequences. So removal may require physical damage if we proceed further along the scale of physical integration. And the underlying interest here is the interest in bodily integrity and security. And this is fundamental. It's one of the primordial things that laws concern themselves with. But here we get into a bit of a complex issue. The law distinguishes between the body and between the objects. And at what point along this kind of spectrum do we start to classify a prosthesis as part of the body versus an object susceptible of being treated as property, of being repossessed, of being treated, if damaged, solely as a matter of damaged goods as opposed to physical injury? This ends up mattering, actually. And a concrete legal problem that might be presented is, what do we do if someone, for example, in a research trial, receives an implanted device? Do they have a right to refuse explantation? What if they have agreed ahead of time as a condition of participation in the trial? Well, we don't typically actually enforce contracts made involving the physical body. It's viewed as contrary to public policy to enforce that kind of thing. So even gestational surrogacy agreements are very difficult to enforce and unenforceable in some locations. Even after, for example, an embryo is donated or given to a gestational surrogate by the intended parents, and then the surrogate does not want to relinquish the baby. So, or I should say, perhaps a better question is, decisions over whether or not to undergo an abortion, for example, are not enforced against the surrogate. So this becomes difficult, this distinction, if something becomes part of the body, and what legal remedy should be employed if a neurotechnology becomes increasingly integrated into the body. So my second category is what I'm calling phenomenological interests in prostheses. So if we step back to non-neuro, sort of more familiar forms of prostheses, a classic example here is given by Maurice Merleau-Ponty, who talks about the blind man and the stick, and he says that after long-term use, a blind man regards the stick as an extension of his senses. The tip of the body is the tip of the stick. It helps him navigate. It's the means by which he experiences the outer world. It's no longer a stick, but becomes part of the body and invisible. This is termed variously embodiment of the device and also transparency of the device. And in fact, it's a design objective of prosthetic technologies that they become embodied, they become transparent. Because if you think about it, the way you write, we all have this experience of our tools becoming transparent. We don't think about the connection between our fingers and the pen to the extent we write anymore with pens, but we think about the contact point of the tip of the pen and the paper. That's where our attention is. That's where our body in quotation marks, ends. That's the point of importance. So this transparency, as I was saying, is an important criterion for the success of a prosthetic technology. And another interesting and I think important point to make here is it's not just a kind of a physical embodiment that can take place, but what's called an affective or emotional embodiment. And this refers to a behavioral and physiological responses toward the tool that reflect its physical embodiment at an emotional and physiological level. So people may recoil and attempt to protect a device from damage in the way they would recoil and attempt to protect part of their physical body in that way. And so one sees examples of this in virtual reality where people become sort of sufficiently identified with their avatar that they experience vertigo or stress responses when their avatar is put in a position of falling off a high building, for example. So my main underlying point here is that you get not just a phenomenological sort of incorporation into the body schema, but this ends up working also at the emotional and autonomic nervous system level of stress responses. There's evidence of brain reorganization being provoked by long-term use. So all of this suggests that with a prosthesis, you can also have interests at the phenomenological level, and the harm that's associated here is no longer physical harm necessarily, but it's a harm of disruption. It's a harm at the emotional level if there is damage to the neuroprosthesis or removal of the neuroprosthesis. And I spoke earlier about the incorporation of haptic feedback, and I wonder if the incorporation of these multimodal or multi-channel forms of relationship to devices might actually enhance this kind of phenomenological interest in a prosthesis. So imagine yourself, I mean, none of us can imagine ourselves, but if we try, attempting to use a prosthetic arm, which feeds back haptic signals from the fingers of the robotic arm into our system. So we're getting sensory perception when the robotic arm touches a particular object. This would be really useful, I think, from a layperson perspective in helping a person learn how to use it effectively, but it might also tend to enhance this form of affective embodiment. It becomes realer, more real, to be getting this kind of sensory feedback from the device. Okay, so my third form of human interest is a survival interest in the prosthesis. And here we're stepping from sort of matters of the organism into functions. Sorry, that's maybe not as clear as I might have been. So stepping away from sort of incorporation into the body schema, and then starting to look at how prostheses can be very important for the continuation of critical functions of the body. And so at the extreme end, you can have people whose very bodily survival as an organism depends upon the continued use of the prosthesis. And this was vividly demonstrated over the last couple of years in disputes over the development of triage protocols for the use of ventilators in some locations where it was necessary, or it was feared that it would soon become necessary, to make choices as to who could have the ventilator. And so quoted by an article by NEMA in 2020 is the statement by Alice Wong of the Disability Visibility Project, who in the context of these debates said, my vent is part of my body. I cannot be without it for more than an hour at most. For someone to take my vent would be an assault on my personhood and lead to my death. And this is very interesting, I think, to use that twin formulation of assault on personhood and also death. So the vent is also being said to be part of the body. This is an assertion, a legal ontological assertion, let's put it that way, from which certain legal consequences are said to flow. If something is part of someone's body, you don't get to take it or repossess it. If it is an object used by someone, well, yes, you can repossess, you can, what's the word I'm looking for here? Expropriate in the interests of the broader community. So, so this is interesting. So there are evidently other instances in which a prosthesis might be critical to survival. And if I turn to neuroprostheses for a moment, one can find a collection of examples where someone who has spinal cord stimulation for chronic pain says, if I did not have that stimulator in my back, I would have committed suicide a long time ago. Again, pointing to the importance for survival of a neuroprosthesis. I did want to mention also the possibility of thinking about survival not solely in a kind of physical whole organism way, but thinking about psychological survival or survival of the person. So if we're to adopt a kind of a John Locke style philosophy of personhood, we would be looking at psychological continuity as the critical element of personhood, that basically that connection between the psychological states over time is what binds all of those temporal stages together and makes them of one person. And John Locke defined consciousness and memory as critical for this, and what allows a person to be one and the same over time. And so as we look at the loss of memory or the degradation of memory functions and the development of neuroprosthetics, such as hippocampal prosthetics, we could look forward to the possibility that a neuroprosthesis might be critical not just to the physical organism survival, but also to the psychological survival of the person over time, if one adopts that theory of personhood. So my next category of interest is sort of like a survival interest, but less extreme. So I'm looking at functions, the important functions that are valuable and important to us, but perhaps the loss of which does not entail our death or the ceasing of personhood. So functional interests in prostheses. So of course, one can think of many examples where a prosthesis, the type of interest a person has in a prosthesis is in relation to its ability to replace, restore, or enhance a given function. And so there's many examples of this with neuroprostheses, one of which is deep brain stimulation for movement disorders, which address difficulties with movement, or others for tremors, or even if we think about the growing interest in using deep brain stimulation for psychiatric purposes, it might be used to maintain a particular emotional state, a particular mental state. This would be a prosthesis meant a prosthesis of the mind or of a mental function, emotional function. And I want to just step sort of out of neuroprostheses for a moment to cite to you two real cases of disputes over prostheses. One is the case of Collins and the airline, reported by Glenn in 2012, of a man who used a very elaborate mobility assistance device, not just a simple wheelchair, but one that was carefully designed to help him remain upright and also to move. It was damaged in an airline travel. And the back of the ticket basically made clear what the airline's obligations were, that baggage, of which the wheelchair, according to the airline, was an example. Any problems with baggage, damages were capped, limited to replacement value. And so that's fine. So if this wheelchair is baggage, well, then it's clear how to deal with the damage to this MAD, mobility assistance device. But really what happened to Collins was that he was out for a lengthy time, developed pressure sores because he couldn't get out of his bed. He had to hire all sorts of people to help him with the needs of daily life. So there were a lot of consequential losses. But also he went further than that and said, this is not just damage to property which needed to be replaced, or even consequential losses from damage to property, but this was in fact an extension of my body, and you damaged my body. This was bodily harm. This incident does not fit in any way under a baggage claim incident related to property. And so there's all kinds of skirmishing. This unfortunately for lawyers anyway, did not go to court. So we don't have a judge weighing in on this. but this was later settled for a much higher amount of money. But again, you see the importance from a legal perspective of which particular legal category we put this object into. Another example from France, a woman went to a dentist and had a denture prepared and fitted. She never paid. She eventually went back to him and he took the denture and kept it. And so this became a dispute, and the French court had to decide, under the civil code, are you allowed to seize for non-payment objects? Well, civil code says you can, but the appeal court said, well, that seizure provision for non-payment of objects does not apply to those that are an integral part of the human person. So again, illustrating the importance of the categorization. So I want to leave you with what I think is a kind of an interesting kind of ethical conceptual question here, perhaps ethical legal question. And that is, how would we apply this kind of reasoning to neuroprostheses that permit supranormal or enhanced functions, as neurotechnologies are developed that actually allow people to do things that are not typical? So there's a little picture below Neil Harbison's antenna, which allows him as a colorblind person to receive some form of sonic information. It's sort of osseointegrated. He gets this sonic information telling him something about the distribution of colors in front of him. This is not a form of information people generally have. What would we say if that kind of neuroprosthesis was damaged? Is it an object? Is it off the body? If we say it's off the body, what bodily function has been harmed here? And what are the damages? What is the assessment of damage to attribute to the loss of what is not a normal bodily function? In the law, we're pretty comfortable, because it comes up a lot and we've had to come up with answers in figuring out how to evaluate the value and the requisite compensation for damage to different bodily functions. But we have no idea how to go about thinking about supranormal or atypical bodily functions of this type. So I have two more categories to put to you. This next one is a social interest in prostheses. So well beyond the kinds of typical bodily functions or survival interests or incorporation into the body, prostheses form or play a social purpose. So there is the fact that certain kinds of disfigurements can cause social awkwardness and difficulty, and cosmetic prostheses can help with that. Equally, different kinds of objects, often worn or even implanted, are used or are important in questions of social identity and markers of group identity. And so there's a variety of case law dealing with, for example, the removal of wigs from people when they go into police custody. Is that acceptable or not, for example? So I guess the point I'd like to make here about neuroprostheses and social identity, let me suggest to you the example of the cochlear implant that many of you are probably aware of, that this is a device that stimulates the cochlear nerve and can help address deafness or severe hearing loss. And in past years, there's been a significant debate that has arisen over the use of these implants in children. One view of it is that this constitutes what is being called an ethnocide of the deaf community. The concern is that in the application of this to children, you're removing the incoming members of the community in a way that diminishes the number of people in that community, the culture, and so forth. It also disparages that culture implicitly. And it also, in a different way, makes an important cultural decision for children before they're able to make the choice for themselves. Of course, the difficulty is it's more effective if used in young children, and they then have a chance while they're developing to learn spoken speech. But in any event, the importance for my discussion here is that there is this view that some of these prostheses might have these social and political implications when used. And this brings us to the neurodiversity movement, which has long argued, or several decades has argued, that we should be regarding non-neurotypical ways of being as merely alternate or different ways of human experience and being and wiring, as opposed to pathologizing and trying to change and cure these ways of being. So I think as we move toward the exploration of deep brain stimulation for a range of psychiatric purposes, and not just deep brain stimulation, but also non-invasive neurostimulation, which is much more likely to be more widespread in use due to its safety profile and also lower resource demands, if it turns out to be effective, of course. How will the application of these techniques to conditions like autism spectrum disorder, where they're being they're being explored in both these non-invasive and invasive forms right now, what form of reaction are we to have to the potential social implications of its use there? So I don't propose an answer to that question, but raise it as a discussion that likely will need to be had, and will likely, it's foreseeable that it will come up. So my last category of human interest in neuroprostheses is what I'm calling an informational interest. And in essence, a neurotechnology represents a novel access point to the person. And this is in several ways. It allows for the insertion of information into the brain and mind of the person directly, as opposed to the indirect means by which we normally insert information into each other's brains and minds. It also allows for the collection of neural information from the person. And as we move, and COVID-19 pandemic has shown how much teleneurology has increased in importance and interest. There's a large number of publications now on teleprogramming of deep brain stimulation devices. This has obvious advantages for allowing therapy for people who don't live next to elaborate medical centers, but it also does potentially expose people to various risks of the compromise of that data stream, and also the deliberate or malicious hacking and misuse of that information, but in bidirectional sense, taking information about the person and feeding disruptive information to the person. And there have been recalls in recent years over security related to other implanted prostheses like insulin pumps. So this is something that must be considered as we move to the networking and the teleprogramming of neuroprostheses. To illustrate some of the ways in which this can come up legally, I refer you to the Compton case, which is a very interesting one, of a man in Ohio who was being charged with burning down his house for insurance money. And the prosecution said that he'd done it and obtained the records about his cardiac pacemaker, and had an expert cardiologist testify that in fact the data was inconsistent with his own account of his activities at the time of the fire. So this was used in essence to impeach the credibility and to prosecute a man for a criminal offense. And so this raises the questions, should other data be stored on prostheses? What can be stored? Should it be made available for these secondary purposes? And I submit to you that if it is collected, it will become used. And let's think not just about cardio pacemakers, but about neuroprostheses, and think about, for example, a communication neuroprosthesis. So there have been several teams looking at how to decode imagined speech from the brain, the motor representation of speech, from people who cannot speak due to paralysis or stroke, or spinal cord damage or stroke, and showing very promising results. And so some of the questions here is, what do we do about a device that is gathering data that can be interpreted? Some sort of, I guess, data that can be interpreted and reflects information that we would tend to regard as rather private and directly and closely related to the person. So speech, I think, would be something of that sort. Now, there's a real question whether this kind of device can actually pick up that kind of internal self-dialogue we have that's not associated with the attempt to move the vocal apparatus. But if it were possible to pick that up, then we have another interesting question, which is how do we treat that decoded speech? Because if you introspect with me for a moment here, that when you speak, you're not ever exactly, when you're speaking in your own native language, you're never exactly sure what you're going to say in the moment. You don't sit there, plan a phrase, and out it comes after you've got it planned. In essence, you intend to try to express yourself, and the specific words chosen emerge in the act of speaking. And so do we treat this decoded speech as the intentional speech act of a person, when in fact we have this kind of simultaneous realization of what it is we say only in the moment of speaking? Perhaps that's no different, as I've already said, that's my experience in speaking to you right now. That's, if it's done by a neuroprosthesis, is there anything different? In both cases, I would follow up with some correction if I detected that there was an error. I guess a deeper philosophical question is my thinking itself only emerging at that moment in which that speech emerges? Am I always aware that that is what I might have wanted to express, or most of the time is that impossible to me and overshadows my original intention and I adopt it? Anyway, these are deeper questions from the philosophy of language to be sort of figured out as we try to unpack agency, free will, neurotechnology, law, and so forth, in understanding what the significance of a communication detected in this way would be. I'll leave with one last observation on this idea of the informational interest in prostheses. And that is, in most cases, these neuroprostheses are used to deal with a disability of some kind. And therefore, to the extent that they produce a novel access point to the person and introduce vulnerabilities for that person, it is going to be people ipso facto with disabilities who are exposed to that novel access point. If Compton didn't have a pacemaker, nobody would have been able to say anything. Well, they might have disbelieved him for other reasons, but they wouldn't have been able to get pacemaker data to impeach his credibility. So it is people with disabilities who are more exposed to this additional avenue of scrutiny by others. Is that fair? Okay, so this leads us to a whole range of legal considerations. Different laws apply to persons and objects. This is an ancient distinction back to the early Roman law at the very least. It may go back further into other legal traditions. Persons can have legal rights and duties, objects cannot. Objects can be owned, they can be the subject of property, persons cannot. Persons can be responsible for things, but objects cannot. The body and the mind also are distinguished in the law. The law is much more comfortable in recognizing and remedying damages to body than to mind. Understanding, I speak about the common law in particular. I think the civil law has been more receptive earlier to understanding personhood, rights, and interests. But there has, generally speaking, been a little bit more reticence to sort of understand injuries to the mind and form rules about that and compensation for that. Another important distinction is between tangible and intangible property. And when we talk about these neurotechnologies that embody complex software and sometimes machine learning and evolving software algorithms, we deal with tangible hardware along with intangible property or software. The laws applying to those are different. And so how do we handle a hybrid or a neuroprosthesis that blurs all of these things together? The body, mind, physical prosthesis, and software that works on it. And so I'll leave you with 4 puzzles, some legal puzzles for hybrids, for hybrid minds. So software is typically not licensed to the user. Sorry, is not owned by the user. Yes. Sorry, did I hear somebody?
Sorry, I thought this was not working.
Oh, okay, okay. Please let me know if I have, I think I'm still okay in terms of time, but do let me know if I'm running over. I'm just wrapping up on the last slide here. So software is typically not owned by the user. It's instead licensed. We all know this because we click here all the time. We download software having not read the license. So these end user license agreements tend to be very restrictive of what the user or licensee can do. So I find it very interesting to think about these neurotechnologies as in essence embodying, especially where it's a hybrid mind, where the mind or the mental properties emerge from the use of this device. The idea of owning a license to your own mind. There's going to be limits on what you can do with the device. I did go looking for the end user license agreement of the Medtronic's latest closed loop deep brain stimulation device. And it's a little bit hard to get these because they're not typically marketed to the patient. It's hospitals that buy these things or doctors or so forth. But one can find certain typical software limitations in pacemaker end user license agreements. So that's one question. Do you own a license to your own mind in this new world of the neuroprosthesis? Second puzzle, who owns neural data? Is this data personal information about a person? Is it an intellectual creation of the user? It could be, depending on what form of data is being collected. But is it to be understood as a co-creation of user and device, and potentially of the inventor of the device and its software? And I have in mind here the important interpretative contribution that the device might make. So we're going to have to figure out the ownership boundaries as well as the nature of this data. Is some of it susceptible of being owned as property? Third, who's responsible for mental states? And this brings me perhaps closer to the theme of this colloquium in its concern with agency and free will. But where a mental state is the product of an ongoing mutual adaptation of mind, brain, and intelligent neuroprostheses, which entity is to be understood as the agent? Who has the free will? Is there anything different in this particular constellation of objects and potential contributors to the emerging mind that distinguishes it from prior discussions about agency and free will, even in the context of use of various tools like an extended mind context? The law is really kind of a bit crude about all of this, and we'll probably come up with some sort of pragmatic solution of the type like a Fisher and Ravizza tracing theory of moral responsibility, where one becomes responsible for the choice to use a particular thing. However, even that becomes somewhat difficult over time if the device itself is changing the ability of the person to choose on an ongoing basis. As I said earlier, if it changes the whether you care or not, your posture toward the changes that the device has introduced affects in an important way whether you know and whether you have ongoing control. So how we sort all of this out is an interesting problem. And then finally, what about legacy neuroprosthetic systems? Is a person entitled to refuse upgrades to something that is a part constituent of the person's mind? Can the person demand support for legacy systems? These again are some of the puzzles for hybrid minds. And perhaps I will conclude there, and thank you for listening, and apologize once again for my voice.
Hi, Jennifer. Thank you very much for your talk. It's such a pity you couldn't be here. We are all very, very anxious to hear from you in person. But I mean, apart from you being in Canada and us here, it was a great talk, and we learned a lot. I spent the last semester of my neuro law class discussing some of your some of the examples, especially DBS that you gave in your last class, in your last talk. I know that my next semester will be filled with examples from your talk today. So thank you very much for this. I have a couple of questions. The first one would be, you talked about prostheses that give people superhuman and extraordinary abilities, and if harm to that would be considered bodily harm. But I'd like to ask you a question from the other end of the spectrum. Would people that are endowed with such big capacities, would they in some way become more responsible due to these kinds of super, or strength or vision or different senses even? I'm thinking about here, the Live Wire, this book by David Eagleman. He proposes that it's possible to envision new senses being added to people. So would that entail different kinds of responsibilities also? And second, you talked about the deaf people, the cochlear implants. There is a case, this is a real case from a deaf couple that wanted to do genetic manipulation so that their kids would be deaf as well, and because they consider that a culture and not a disability, and that went to courts in England. I'd like to hear your take on that as well. Okay, thank you very much.
Thank you so much. This question, I'll speak, I'll respond in the order of your questions. So this idea that people who are enhanced, who acquire unusual abilities might, let's just say, rather than more responsible, say that we would tend to expect more of them and condemn them for falling below a higher standard of behavior. I think that is possible. I mean, I think there's various instances in the law where people who have acquired unusual abilities are held to a higher standard, at least in certain contexts. So a very uncontroversial and familiar example would be medical specialists who, in having acquired surgical expertise, would be expected to perform surgery with the standard of care and the abilities and knowledge and so forth and judgment that is usual amongst surgeons as opposed to among psychiatrists or among some other medical specialty. So if you do acquire certain enhanced abilities and you are using them in a context where those enhanced abilities are expected and required, you will be blamed for not doing so. So I guess the question is, does that kind of thinking, can we envisage it translating to the context where someone, for example, develops the ability to see magnetic fields, for example? And so it's a little bit hard to see right now where that would be a useful kind of ability, or perhaps my imagination is limited. Maybe that would give you access to some form of information that would help you to avoid collisions, car collisions or something, and you decided not to use that ability even though you had it, or you were in possession of information that would have allowed you to avoid a harm and you didn't bother. I think it's an interesting question. I'm not sure about the answer to that because the negligence standard often ignores the difference between people. It requires people to live up to the so-called reasonable person standard. And so the question would be, would a reasonable person in these circumstances have reacted as you had? And would a court personalize the standard by imagining a reasonable person like you in the possession of that unusual faculty? We don't tend to do the other direction of saying, well, someone has diminished capacity, therefore we'll hold them to a lesser standard. So would we actually hold someone to a higher standard? There is, of course, the letter of the law, and then there's also the psychology of blame. And so it may be that an adjudicator might look at these facts and feel a little bit angry at someone who didn't use that knowledge and ability to avoid harm, even if they could have. And even if the law didn't direct a particular response, might find a way to say, well, in this case, clearly that fell below the standard of care. So there is that possibility as well. So anyway, this is a very long-winded way of me musing out loud without coming to any clear conclusion. But perhaps I'll stop and move to your second question of the deaf couple who sought to have genetic manipulation. I don't remember if they sought to actually select an embryo bearing congenital deafness. I think that was it. It wasn't a gene therapy kind of move, but I can't remember now, Renato. I think that it's interesting to speculate, would the answer have been different if the attempt to have a deaf child was done by selection of a deaf embryo versus an embryo bearing that gene for deafness versus an attempt to genetically modify the embryo. It seems, those seem to me different actually, as I think about it. But in any event, I think that it's an interesting question, and it does starkly raise this particular difficulty of trying to be clear on what is a harm to a child, what's to be understood as a harm, because the parents obviously did not view this as a harm to the child. And this is the thrust of the general neurodiversity movement, that we should not be pathologizing things that are, according to the majority, viewed as impairments, that these are not necessarily bad. They might have an upside that reasonable people might desire to have. So, and this is of course a problem throughout much of psychiatry as well, not just with sensory issues like hearing. So there is this question about how to understand harm and what ways of being and experiencing the world are to be viewed as impaired or pathologized, but it also is very much about the contest, or what I should say, the scope of parental choice in relation to the lives and destinies of their children too, which is a whole other legal domain of difficulty. And we had a case in the last couple of years here in Canada, which put this sort of squarely before the Canadian public. It was two young girls with childhood blood cancers, leukemia, lymphoma, I think. And both girls came from the Indigenous community. Both were, I think, Mohawk, members of the Mohawk community. And both parents refused chemotherapy for their children. And this, of course, went to court. The Children's Aid authorities stepped in and said, this is medical neglect. We will take over responsibility to decide for the child. And this went to court. And the judge said, actually, no, there is sort of Indigenous worldview at work here. And this is, we are going to put a limit on the extent to which the broader society can step in and replace parental autonomy in relation to the children. So this is different from how a non-Indigenous child would be treated. The courts have and will step in and authorize medically necessary treatment for the children if it is recommended. But this was a different limit for this community. So that's a whole other question that I think is invoked by the point you make.
Do you hear me well, Jennifer?
Mm-hmm.
Right. Is there any questions? Because I have a couple. Someone, can I go for it? Yes. Okay. In 2014, Brazil World Cup, a paraplegic person was the responsible for the kickoff. The kickoff of the World Cup was done by a paraplegic person using an exoskeleton. That was the Miguel Nicolelli's research, Brazilian neuroscientist that works in Duke University. I mean, let us talk about this kind of hybrids. kind of cyborgs. Let us call those kind of hybrid cyborgs. We have some electrodes implanted in the motor areas of the brain. We decodify the signal. You send the signal to mechatronic limbs. And those people, paraplegic people, for example, could just walk again. That's wonderful, wonderful, wonderful research, wonderful results. But if we think in terms of teleology, causa finalis, as we say in Latin, the applications of it, meaning the applications of it, we can imagine different scenarios. Instead of making paraplegic people to walk again, we can have mutilated soldiers back to battlefield using exoskeletons, really hard to die, you know, just titanium exoskeletons. Imagine that scene. Titanium exoskeletons reach countries, invaded poor countries using cyborgs. So, I mean, I think one of the issues that your talk raised is about the applications of those techniques. I think the most important legal considerations are among the applications of those technologies. Establishing limits for such so powerful technologies to be applied, ethical and legal limits for that. I would like to hear a little bit on that, on cyborgs and limits for applications of those techniques for different purposes, right? The second question is about the co-creation of the data for example, in those kind of BCIs, they are biologically important for the survival of a creature, like pacemakers, this kind of devices. I mean, of course, there's some interaction between your body and the copyright owner of the device, of the software. I mean, probably the owner of the copyright of the software. But even though I'm not using those devices because I want, I use those devices because I need it. I mean, someone that uses those devices are not opting for use those devices. They are forced to use to keep their normal health. I mean, to keep their normal homeostatic states. It's not an option to use a pacemaker. It's a necessity. So, I mean, the idea of a co-creation maybe presupposes, let us say, my will, my freedom to choose to use those devices. But if I have to use a pacemaker because otherwise I'll have a heart attack or whatever, it's the consequence of not using such a device. It would be fair to say that this is a co-creation. I mean, I mean, my co-creator, my partner here is not someone that I'm opting to work with. It's just someone that I'm forced to work with. So those are my two questions. I'll love to hear on those subjects.
Oh, okay. Yeah, thank you very much. So let me start with the co-creation example. So what is likely to be, let's think about the devices that detect imagined speech. So what is very likely to be the case is that there's going to be some form of, like, some analog of an autocorrect function going on here that attempts to try to backfill in what you're trying to say according to some sort of algorithm that allows it to guess based on context and what other kinds of words went before and after and so forth. So there is going to be some other participant in creating the utterances that you make. And so, not to get silly with my example, but imagine you're composing a poem with this device and you're like, huh, I'm not sure I meant that, but I like that other word better that came out of this autocorrect device. Is that a co-creation of an artistic product? I think I got and so the idea that co-creation presumes freedom to use, I guess I can come up with hypotheticals where that there's a requirement to use to achieve a certain function, but still one can engage in creative activity that might be understood as something subject to intellectual property rights. I was sort of provoked along this line by a paper by a legal scholar who was talking, and I'm trying to remember his name, I'm sorry, I can't remember right now, but it was one of these sort of sci-fi-ish legal articles talking about mind movies, and it was looking at the work from the lab of people like Jack Gallant, who are trying to decode from neural signals what a person is seeing. And there's lots of interesting videos on YouTube of decoding these blurry images from the brains of people, which sort of more or less represent in a blurry way what someone is seeing on a movie. And so he raises the point of, well, isn't this neat? Couldn't you use a device like this, for example, to make mind movies, to record your dreams? And what would, all this obviously admittedly highly speculative, and will this be possible? Who knows? But if we accept it as a thought experiment that it is possible, what would be the status of that mind movie produced by the unconscious dreaming person? Is that not a creation at all because it's not voluntary? Is it just personal information because it's information about what the contents of the dream of a person are? Is it, if it does produce an interesting work that seems to have artistic merit, are we then to attribute it to the device that collected it if it wasn't deliberately created by the dreaming person? So anyway, a couple of examples. I do take your point, though. This is, and I admittedly, this is all in kind of speculative stuff, but I think still interesting to think about in terms of characterizing the type of information that can be collected and the manner in which it can be created, as including different types of contribution from different parties, and then trying to figure out, is it of the person? Is it of another person? Is it susceptible to ownership? What forms of privacy protection does it attract? And so forth. I think your other question had to do with the purposes of the use of these technologies. And of course, yeah, I think that, I mean, this is always an aspect of big interest in ethics and law. And I don't think I can give an answer in the abstract as to what, in my view, might be an appropriate use of some of these technologies or not. I think it would depend very much on the particular technology. But maybe it's helpful to say one different thing, which is one can try to regulate the use of a given technology, like ab initio, to stop people from acquiring it, stop people from using it in certain ways, in certain contexts. Or another way to go at that is to regulate the downstream products of that inappropriate use. So if we think, for example, of the collection of neural data as something that concerns us, well, we could say something like, you must build a device that does not collect this data, or that retains it only for a short period, then deletes it, or something of that type. Or you could say instead, well, if you happen to collect this data, it cannot be used for purpose X. For example, it cannot be subpoenaed in a court of law to be used against a person because it would, for example, constitute self-incrimination or something like that. So there's different ways to get at the particular concern we have with use that is not necessarily aimed at its deployment, its properties in general, its deployment in a given set of contexts, but instead the downstream use of it in particular ways, which is another way of going at the issue.
Hello. Oh, okay. And we are back. Thank you very much, Jennifer. Wonderful answers. We have a question for Sinara, also a speaker, invited speaker of the event. She just sent her question by Zoom. She says, thanks, Jennifer. What about enhancement prosthetics? Do you think that people could claim they have the right to have this kind of prosthetics implanted on their bodies based on the rights of free will? And what about access point to the person? How to avoid private companies in the future using your neurodata without your consent? Do you think is it possible to implement international regulations to cover this problem?
Yeah, I think that on the first point, I think the various sort of cyborg rights declarations are essentially calls to be allowed to do just that, to use whatever technologies a person desires to try to enhance their abilities. And in many respects, there's quite a lot of freedom to do that. You can find, for example, online also a whole DIY community that designs crude neurostimulation devices to supposedly help in focus, attention, playing video games, things like that. So yes, I think people could claim a right to be allowed to have this kind of device implanted. Notice that when someone claims a right, that implicitly suggests that someone's trying to stop them. So the need to claim a right would mean a government has stepped in to try to prevent the use of a particular technology, and then the person is claiming a right to be allowed to do it. If the government doesn't step in, then I guess people just do what they want to do with these kinds of enhancements. With the second question, to avoid private companies using neural data without your consent, I think yes, it is possible to pass regulations of that type. I would suggest international regulations probably. I mean, it's nice to have some international consensus given the international flows of personal data and sort of the multinational nature of many large companies. But in terms of domestic enforceability, it might be best to go with domestic regulation. The European Union has been highly effective with their general data protection regulation, in essence, giving extraterritorial effect to their own regulation, and having people and companies around the world have to abide by it to the extent that they handle any European touching personal data. So there's various ways of doing this. I think the complexity here when we talk about neural data is we need to define what this actually is. It may well be that if the things we're concerned about constitute personal information, then they're already protected by various personal information regulations, and we don't need a new regulation. The other difficulty here, which pervades the regulation of private personal information, is that it's exceedingly easy to get people to consent to the use of their information. People will voluntarily give it up far too easily. And so any data protection law that's based on consent is pretty quickly going to become a pretty weak law. So we have to think about whether additional restrictions should be used on or placed on the use of the information, so that you must have consent, but also the use the information is put to must be reasonable according to some set of standards. So you cannot rely on consent to something that's unreasonable, for example. So those are a few thoughts on attempts to regulate this field. These are all great questions. Thank you, everybody.
Thank you. Hello. Okay. Thanks a lot, Jennifer. That was wonderful. Someone else from the audience has questions? Marcel, please.
Yeah, I was very interested in this question, who is responsible for the mental states? And I saw that you made a very interesting point here, namely that in normal psychological function, the same question arises, or the question is whether it's so different with neuroprosthesis, because when I speak or produce mental states or actions, I also don't really understand the mechanisms that produce them. The question is only whether I have the experience that they belong to me or that I'm the agent that produced them. So I wonder whether there is such a fundamental difference with neuroprosthesis in a way. Of course, it's obvious that there is something external that is producing it, but from a phenomenological point of view, it's not so different, isn't it?
Yeah, and I confess I don't know the answer to this, and I struggle to think about it conceptually. I'm not deep in the philosophy as many of you are. Excuse me, but it seems to me that we have difficulty identifying the agent here. It's true that when I speak, there's many things that are contributing to what I'm saying, including various, I presume, aspects of the environment that are influencing me and so forth. Is it any different that a neuroprosthesis might be contributing to my emotional makeup and my attention to particular stimuli and so forth? Is that any different because it's a visible, known device? I'm not quite sure what to say there, except that the involvement of another entity that we would clearly recognize as an agent, namely the inventor of the device, has sat down and created this input deliberately and created the software deliberately and has, we presume, some sort of responsibility or knowledge of its operations, and then put it in motion with me. And so I suppose it feels like an instance in which there's two potential agents producing the mental state and the output in a way that is more obvious than if it were another human interacting with me in a different way. Perhaps I'm wrong about that. Perhaps there's no particular difference. I do think there's something to be said also about the sort of the emergent properties of the whole thing. So if you have a closed loop deep brain stimulator that, you know, I've read about, again, on the speculative end of things, wouldn't it be great if we could have a deep brain stimulator for addiction that uses GPS and all kinds of biomarkers to determine when I'm in the proximity of a casino and stimulates only at that instance, and also in detecting certain other cues, and so and optimizing it over time. So if it's attempting to optimize for a particular output, the various inputs into it over time will change, and nobody will know what they are, not the user, not the other agent who designed the system. And so is that different in trying to sort out the free will as well? That there becomes an input that is, again, invisible to both of the two other potential agents involved in that collaboration. I don't know. What do you think?
Yeah, I find it extremely interesting because, I mean, the system that you are describing, that's how our brain works in a way. It responds to a specific context, learns stuff. So in a way, our natural system might be very similar, and it's not transparent to me either, in a way. So the crucial question is then whether I experience it as a result of my thoughts or actions, or experience it as being external in a way. And of course, even with my biological system, I can have this experience when I'm schizophrenic. I can have the experience that someone else is talking to me, even though it's obviously a result of my brain function that is producing it.
Mm-hmm. I think one thing that is very interesting about all this too is the potential to separate out, disaggregate aspects of our own, I don't know what term to even use here, cognition. If I return to the example of the person with DBS for obesity that succeeded in reducing the reward of eating for the person, but the person remembered, hey, I actually like eating. I'm going to deliberately go over at night and turn this thing off and eat. This is super interesting because it in a way, it allows us to separate out the components of complex behaviors and mental states, modify parts of them, leaving the others intact in ways that they continue to operate. Or we have an example where we separate out aspects of a complex behavior, like the Parkinsonian DBS recipient who all of a sudden decides they love to do pathological gambling and doesn't care. So even if we like identifying with the output or the new hybrid mind itself doesn't seem like a complete and good answer, because it may well be that the device itself can make you like the new you and the new change. And do you then, is that different from the way you might have been before in terms of identifying with your mind and the products of your mind when you don't know how they're produced? Is there some more worrisome manipulation at play there, or potential for manipulation or not?
Thanks a lot. Thanks for the inspiring talk.
Thanks, Marcel. Thanks, Jennifer. I think we had questions from Peter, from the in-person audience. We have another question from Sinara, from Zoom. So let's start here with Peter. Whenever we're ready for the Zoom question, please.
Hi, Jennifer. Great talk, and thank you. It's Peter C. here. Yeah, so I'm interested in, often people talk about volition, but really some of this is driven by desires, and people make the distinction between first order desires like wanting to eat ice cream and second order desires like not wanting to eat ice cream because you don't want to gain weight. So I can imagine your devices that will manipulate your desires. And I'm sure a lot of people would like to turn off their desire to eat ice cream, but maybe there would be other devices that would affect second order desires. Like I want to become the kind of person who would want to eat less ice cream. That's sort of a silly example, but my worry in all of this, if we can begin to manipulate desires, is the rise of tyranny, actually, that the rise of a kind of Orwellian world in which, the CIA or governmental structures might be able to implant in babies some kind of device that would make them, say, want to comply. And I'm just wondering what your thoughts are about the dangers of the rise of tyranny, what the framers of the US Constitution were trying to preempt by setting up the Bill of Rights. Is there any kind of Bill of Rights that will be necessary to preempt the possibility of the rise of an Orwellian tyranny that could flourish because of the possibilities afforded by these devices that will change how people desire? The government obviously would want people to desire to comply. And when they have that device in them, they're happy to do so. But obviously, they might not have chosen that had they not had that implanted in them as a baby. So I'm just wondering if you have any thoughts on the possibility of the rise of an Orwellian state.
Yeah, I think. I think it is a possibility. And where my mind goes with this is, okay, say a state tried to fit people with the special little compliance chip, the good citizen chip that we were all going to have and was going to make sure we toe the line all the time. I imagine people would not like this very much. There'd be a lot of resistance. So the question is, how would this be presented as an offer you cannot refuse? Because as Foucault said, the best form of exercise of power is to get the person to demand to behave in the way you want them to behave. And that's the more sophisticated exercise of power. And so I begin to wonder what structure gets set up so that we all want this and it's in our interests. And you can imagine situations in extremis of great civil unrest and danger when people often sort of demand and comply with authoritarian government moves. But short of that, I'm thinking also about, I did a study a few years ago of the use of what I call quasi-coercive consent to biological therapy in the criminal forensic context. And so looking at how people who are, the legal and medical system basically make it so that people who are, for example, convicted of a sexual offense will want to have anti-libidinal drugs. So here's an example, not of a neurotechnology, but of something meant to control desire, obviously, sort of certainly at the first order level. And the idea is to do counseling work at the second order to become the kind of person who is not giving into paraphilic urges, for example. But the way it works out in the court is everybody knows, the defense lawyer knows, that if someone shows enthusiasm for this kind of self-fettering, this kind of Ulysses type self-control, that is interpreted as a symbol of taking responsibility, and also prospectively as bearing positively on their future risk profile. So everyone knows that, and they know that the two things that are important to sentencing are the retributive impulse of, do we blame you or not? Have you taken responsibility? But also the prospective, are you dangerous to us in future? And so in answering both of those by demonstrating a willingness to take on this biological intervention to control yourself, you do much better legally. And so it was interesting interviewing forensic psychiatrists about how they think about their role in all this. Are they part of a state apparatus meant to create this kind of control? Or, and I had some psychiatrists say to me, look, I got nothing to do with government or criminal law or whatever. I have someone who's got a problem. They come to me, they say, hey, I've got to control myself or else I'm going to get into trouble. I supply the control. So it's easy for the various parts of the system to lose track of how they all fit together to encourage a particular form of control. So anyway, this is a long-winded answer, but it's just a bit of a musing on how this kind of thing can come about, if not for the whole population, certainly for some subsets of it.
Thank you.
Victoria, where's the scenario question? Is scenario ready to jump in? Scenario from Zoom.
No, sorry. I think that I touched something here that I shouldn't. I don't have any other questions. Thank you very much, Jennifer, for your reply. I'm satisfied.
Okay, so you just left the rent.
Yeah, I think I made some mistake here. Sorry. Okay. I'm satisfied.
Anyone has any other question? Feel free to jump in.
I should have said while I had Peter there to thank him very much for his talk, which I enjoyed very much. I was out in Zoom land at that point.
Great. So please, a big round of applause for Jennifer Chandler.